Thank you. I told him early. I totally forget to do that. Anyway, Diane Drain, co-executive director for ACBC, the chair of the communication CLE, etc. And so today, now some of you I recognize some names on. You were here yesterday when we had the speaker talk about AI and chat and all that, and our minds were just literally technology-wise blown. So welcome back. This program is scheduled for 2 hours. That doesn't mean it'll last 2 hours, but if I know John's programs, it'll last 2 hours. And he's going to have some housekeeping things. I will be posting the CLE certificate at the end of the 2 hours. So if you aren't able to download it for some reason, you just email me at admin@acbcforum.org, and I'll be happy to send you the CLE certificate. Or if for some reason you're not able to download the materials, which I have just now uploaded, and I'm going to periodically, like every couple minutes here, upload them again because the new people that are signing on are not going to see what already got uploaded. So when we have our latecomers, so don't get concerned that you're seeing 3 different versions of the same document. You're not. It's one. All right, as far as other housekeeping, this is being recorded. It will be available on the ACBC YouTube channel. It will also be available on the ACBC website. As will the materials that Jon has so graciously provided. So they're on the website and I'll be posting them here. Okay, enough of that. Jon, take it away.
Okay, thanks, Diane. I'm happy to be here. Jon Hayes, you can tell by the name and my picture. I'm the president of the Central District Consumer Bankruptcy Attorneys Association this year, and this is a program that we've done for 20 years now. Our organization is 23, 24 years old, I think, and it works really nicely. It's a great organization. I've been practicing for 46 years, almost entirely consumer bankruptcy, although I'm not in the trenches that much on Chapter 11s. Anyway, we have Judge Julia Brand with us from the Central District here. Judge Brand I was actually afraid to ask you, Judge, to do this. I mean, I just can't imagine how busy you are, but Judge Brand is the chief judge of the Central District. We have 15 or 16 judges or so now. She's also sits on the bankruptcy appellate panel. That's been close to 10 years now, right? Is
Yep.
your term?
My term ends this year at December 1st, and I am also chief of the BAP now too. So,
well, we really, really appreciate you being here. I saw your name on a whole bunch of my slides, so we can find out what in the world's going on in some of these cases. And then we have Judge Dan Collins from Phoenix. You all know Judge Collins. Judge Collins and I had a chance to get to meet each other up in Spokane several years ago at the Judicial Conference, and so you've been on the bench now since 2013.
Right, January 2013.
University of Arizona Law School, and so anyway, what we're going to do is I'm going to post the slide. We have about 22 cases altogether, and I'll post the slide, but that's really just to tell you what page you can find the case summary. I should I should go back. Did Judge Brand or Judge Collins, did either of you want to make any comments?
Judge Brand,
How
go ahead,
much you
please.
enjoy being quoted from these programs?
Thank you, John. Uh, and I'm sure Judge Collins will fill in anything I missed, but of course, we're here in an educational capacity. We're happy to talk about these cases. I am happy to talk about these cases, happy to share my thoughts regarding the BAP cases that I participated in. But you should, we're not telling you how we would rule on the bench. You should not take the information or anything that we say here and try and cite it back to us in a brief. But you said at that program, XYZ. This is really just an educational format, and it should be used for nothing else. Judge Collins, did you want to add anything?
Yeah, it's not only education. I'm hoping this is semi-entertaining as well. And
Yes.
all those reasons, we don't want to have this fed back to us at any time. We are thrilled though that we got such a big crowd and really appreciate ACBC stepping up to let this happen. Now, John, one thing you didn't mention, I don't think, was that you were a longtime BAP law clerk with Judge Taylor and Judge Lafferty, and so you are very keyed into appellate work, and we're going to be looking a little bit at that today and asking you some questions about how things are done at the BAP from your perspective, because you're the first one to touch those briefs. But
Yeah, boy, it was just fascinating. I did it well on into my career also, so it was, but yes, especially if Judge Brand agrees, I can.
Absolutely. We were very happy. I was particularly happy when you agreed to be Judge Taylor's law clerk at the end of her term. So, and then carried on with Judge Lafferty for a while. And the other thing I would also mention too, because Judge John does not blow his own horn at all, but he's been doing these programs in the Central District of California for so many more years than I can even imagine. And they're always entertaining. They're always enlightening. I've done 3 or 4 of them with you, John, and I've always enjoyed that experience doing it. You give us so much good material to work with, and I agreed to do this even though I am super busy because I get to work with you and, of course, my good friend Judge Collins.
you're kind to say that, John. We are very pleased that you would take the show on the road here, so to speak. But it can't pass unannounced that you, like Judge Wansley, are a grad of Gonzaga. So I don't know if she's on the program here today, but the Zags are having another good season.
Oh, I didn't know she went to Gonzaga.
Yeah, otherwise you would have called her instead of me, I suppose.
Oh, Diane is the one that Diane. I mean, I mentioned it to her, and she said, "Oh yeah, yeah, we want to do that. Ask Judge Collins." And
Mikey will never say no. And Judge Brand, last time I spoke with you was at a business class at USC. We were doing a program there, and so it's really a joy that you'd be willing to do this. And are we going to see you out at the Dodgers spring training this year? That's where I saw you one year, just kind of ran into you there.
Yeah, no, I don't think we're going to make it this year. There's too much other things going on, but I'm sure I'll have another reason to be in Arizona sometime soon. So I will see you then.
Okay, terrific. All right, with that, John, let's hit it.
oh, great, yeah, great. I see somebody else went to Gonzaga. My oldest son, went to Gonzaga, and his oldest son just graduated from Gonzaga. So we love the place. But so what I'm going to do is post we have the PowerPoint that we passed out to everybody. And the PowerPoint, I'm only going to leave it up for a minute or so. And then I'll take it down and we'll continue to talk about the case. As far as questions go, like I said, we have about 22 cases to talk about, and typically we don't get through even 20. We get through 16 or 17. And so, I mean, questions can be a little tough too. For one thing, I can't be looking at chat while I'm trying to figure out what to say. But if I told Diane, if she sees a question that she thinks, fits in nicely, and is what we're talking about. Diane's welcome to chime in and tell us that somebody's asked a question. We'll try to leave a few minutes at the end if there's any questions also, but we'll see where that goes. So the first case is actually, I mean, where I usually start is the Supreme Court, which is kind of funny because there's only one Supreme Court case this year, and it's not in the materials, and it has to do with sovereign immunity and this really arcane. It's in my I have a case summary of it, but we're not going to talk about it. And you can always tell how arcane it is when the junior justice on the Supreme Court gets stuck writing the opinion. You can tell how arcane the issues are. So where we're going to start is this Keithley case deals with judicial estoppel. It actually, the Supreme Court hasn't ruled on it, and it actually oral argument now is set for March 24th, 2026. You can listen to oral argument if you go to the website called scotusblog.com. You can find the link to listen to oral argument if you want. But you know what? This is the Chapter 13 case, and the debtor got a plan confirmed. And about a year after the plan was confirmed, the debtor's in a car accident. And apparently he was hurt pretty bad. I think he spent a few weeks in the hospital. He says he told his lawyer that the lawyer didn't get his 2 minutes of rebuttal on that, but there was a motion to modify the plan. Let me close this now. There was a motion to modify the plan because his income went down. But there was no disclosure that he had this claim now against the truck that ran over him. And about 4 months after the car accident, he sued the trucking company in district court, in federal district court, based on diversity. And to jump to the end, the district court dismissed the case and said, this is you didn't tell the bankruptcy court, and we'll get to what judicial estoppel means, but because you didn't tell the bankruptcy court, that's only one part of the rule, but because you didn't tell the bankruptcy court about it, you lose the right to prosecute what is obviously a sizable claim. It's the Fifth Circuit. The Fifth Circuit agreed that you didn't disclose that. That's that. And now the Supreme Court is going to revisit that. Judge Brand or Judge Collins, do you have any thoughts on this?
Go ahead, Judge Brand.
It's an interesting case because this is not the way we usually see this issue come up. First of all, it's Chapter 13. Often we're seeing it in a Chapter 7 case where there's a lawsuit or personal injury lawsuit, for example, where the debtor has not disclosed it, but then pursues it. And often we see the creditor then, the defendant then bring it to the bankruptcy estate and say, hey, this is really your claim, and let's settle it. So that's the usual arena where we see this arise. And this is different from that. This is the kind of weaponizing judicial estoppel in the underlying lawsuit by the debtor. The summary judgment was granted in favor of the defendant, so that the defendant basically gets a windfall because judicial estoppel has been used kind of like a sword against the defendant. For me, there was the dissent, which talked about the purpose of judicial estoppel is to preserve judicial integrity. And it's really important in the bankruptcy context because we want all of the assets to be gathered into the estate in a Chapter 7 case. We want the trustee to be able to distribute everything for the creditor, and then the debtor, the honest but unfortunate debtor, gets the fresh start and the discharge. And so that's where I think it works really well. It kind of doesn't work as well in this context, and I'm not sure. I'm not sure how much of an impact this is going to make overall. I mean, we've got the Supreme Court argument about it, but judicial estoppel doesn't apply if the disclosure was inadvertent. It has to be intentional. And here, I think maybe there's an undercurrent that this debtor wasn't really honest and, was hiding it, hiding the lawsuit because he had many opportunities to disclose it in the Chapter 13 case.
So here, judicial estoppel ended up working to the detriment of all the creditors of the
Mm-hmm.
case, not just the debtor, right? Is that how you look at it?
Mm-hmm.
Do you think the court was all concerned that perhaps the debtor had an exemption in this claim, and maybe that money in part or even wholly was not going to land in the estate?
Yeah, quite possible.
It does seem kind of weird for the Court of Appeals to be saying, I don't really believe, they didn't say it in these terms, but I don't really believe that the debtor, it was inadvertent in this non-disclosure. That's really something reserved for the trial court, not for the Court of Appeals.
So is there a lesson for, debtors counsel in this type of thing?
Of course, disclose,
Right.
and stay
Yeah.
on top of your people to make sure they disclose to you as well, and do a little CYA action with an occasional email saying, "I'm reminding you if something comes up, you've got to make sure you tell me so I can disclose it."
I've had clients call me from court, and I say, "Well, I'm in court." They're talking quietly, I sued my doctor, I sued the bank, and the lawyer's telling me that you, meaning me, the lawyer's telling me you forgot to disclose this litigation, this claim I had against the bank, and now they're talking about dismissing it. I mean, when I interview clients, do you have the right to sue anybody? Oh, no, no. Would you like to sue anybody? Well, your landlord, your ex-wife, and there anybody you want to sue? Well, I can't afford it. What if I get you a free lawyer? Would you sue anybody? I'm trying to drag it out, that you might have a claim, but
Well, I can see why that's really good practice. In reality, does that actually happen? A lot of times these people are being interviewed by the paralegal or somebody who doesn't really even think to look at it that way. But good for you. That really is going deep and really trying to shake the trees.
well, yeah, and it comes up so often. I did make a comment on it, and we can finish on this one, but the judicial estoppel really requires two things. And I looked for it in this case, but the first thing is the failure to disclose, but this to the first court. But the second part of that is you have to actually get something from the second court, from the first court, that is at least in part based on the failure to disclose. And in this case, the plan was already confirmed. And the debtor's argument was none of this would have gone into the estate anyway. I have no idea if that's true or not, but what did the debtor get when he didn't disclose this car accident? Which actually was a little surprising to me that it even needed to be disclosed once the plan is confirmed. There's some confusion, I think, about what needs to be disclosed after that. But anyway, what the court said, I found it. What the court said is the MOMOD, the motion to modify. You went into court and asked the court to modify your plan. They might not have done that. The judge might not have done that if you had disclosed this car accident. Therefore, you got something that was based in part on the non-disclosure. Judge Collins, I was going to ask you, do you guys, is the property of the estate automatically revert when the plan's confirmed in Arizona?
Depends on what your plan says.
We have a choice.
Well, we have a form plan, but I don't think it's absolutely crucial that you use that form and only that form.
So in our district, the form says it doesn't revert. The property remains property of the estate.
I haven't thought about this one for a while, but I know somebody that absolutely will know this, and we're going to call him out because I see his picture on the screen. Russell Brown, you're one of our two Chapter 13 trustees in Phoenix. What is the Chapter 13 trustees' view about whether it reverts or not upon confirmation?
Dang it, Judge, I knew I should have changed that picture or something on there. Okay, so if you're talking about Keithley, then, that's a post-confirmation personal injury claim. As to vesting or not, the Arizona plan form, the debtor gets a choice. And I think the presumption of the code is that it reverts back to the debtor and it's not part of the estate. But problem if it's not disclosed, then I think there's another issue there. If the trustee could argue that, it's still property, the bankruptcy estate, it wasn't disclosed. Now, as a practical matter, what we try and do is look at a totality of circumstances and see if perhaps the estate, probably generally the unsecured non-priority creditors would get some funds out of that. But again, I would look at it, how much is the debtor getting? Things like that, the expenses incurred by the debtor in prosecuting that litigation, how much the debtor's already paid into the case. So I don't try to get really greedy on a post petition claim, even if it was disclosed, debtor filed an amendment or whatever. So I try not to, I think, get too greedy on those.
As a practical matter, I think Judge Brand and I are on the same page here, which is why let the tortfeasor off the hook when either it's the debtor or the creditors of the estate stand something to gain here. That doesn't seem like a fair windfall, but that is the result from the Fifth Circuit there.
Clearly in the Ninth Circuit, I try to not say clearly, but clearly in the Ninth Circuit, the rule is it has to be inadvertent. The person claiming that the case should be dismissed has to establish that it was not inadvertent. So this Keithley case, it could screw up the Ninth Circuit, and if they rule that inadvertence, well, maybe, or if they're wishy-washy, and they lean it all towards, it's a hard and fast rule. Otherwise, it's not really going to change how we function in the Ninth Circuit. But let's move on. The next case is the Supreme Court actually just came out with this case, which I don't think we need to. The punchline is really simple. These 60B motions, these motions for reconsideration. Judge Jury corrects me every time I say that, there's no such thing as a motion for reconsideration. But if you're arguing that the judgment is void, is there still a reasonableness component? You have to bring the motion to vacate the judgment within a reasonable amount of time, even if the judgment is in fact void. And the Supreme Court had no problem with that one, it's the reasonableness time limit is still there, even if you're arguing that the judgment is void. I know judges love motions for reconsiderations in general, but do you have any thoughts on this one?
Well, let me talk about motions for reconsideration generally. If I really truly got something wrong, I would rather you bring that motion for reconsideration rather than read about it when the district court or the BAP reverses me because of something I just simply missed or got wrong. So I'm not offended by motions for reconsideration in a general sense. Well, what about you, Judge Brand?
No, I agree with you. In fact, I recently granted one. So,
If I'm wrong, I'll admit it. Let's get it right here, because that's really, I think, my main job, not just to be right, but to try to get the matter right if I really was incorrect.
The problem, again, from the lawyer's viewpoint, is that some lawyers, and especially pro pers, every time they get a ruling they don't like, they file a motion to do it over again, and we wind up billing our clients.
Yeah. Well, there is that, of course, and that seems to be even a bigger problem in California. But we've inherited some of that problem here as well. The proceeds, particularly now they've got AI to generate the
Yes.
proceedings. They can do it swiftly, and now I can actually read the handwriting because it's all in print rather than their handwriting.
Yep. And with this case, I agree, it's pretty straightforward. And they had good facts to work with here because this creditor knew, you know, they knew about this judgment. They just didn't do anything about it until the trustee got good or at enforcement. They had some success in enforcing it. And so then that's when they said, oh, wait a minute, this judgment is void. So they had some good facts to work with here. I was trying to think about situations where this could be a problem because often there's a void judgment and the defendant doesn't even know because there was bad service or there was something. They have no idea that the judgment is out there. But hopefully they should still be able to work within this reasonable time concept because it's reasonable under the circumstances, I guess. So, yeah, those are my thoughts.
I have no problem with what happened here.
All right, well, let's move on to lawyer's favorite topic, attorney's fees. This is a BAP case that Judge Brand was on the panel. This came out of Sacramento. The attorney charged $7,200 for apparently a run-of-the-mill Chapter 7 case. And God only knows how, but he managed to get the filing fee waived at the same time. And there was the court had set an OSC because there was some issue that will probably come up in our discussion, but there was an issue about the lawyer's comments or the lawyer's representations about what he was going to do for all that money, And, the lawyer gets in front of Judge Jaime then, and Judge Jaime says, "Oh, by the way, where'd $7,200 come from? That seems a little steep. Why don't you tell me why that's reasonable?" And the lawyer did not do a particularly good job of that. And at the end of the day, the bankruptcy judge said that $7,200 is too high based on what I've been given. I think $4,000, based on the judge's research, $4,000 seems to be reasonable. And the lawyer appealed. And well, what do you think, Judge Brand? You were on that case.
Yes, I was on that panel. Judge Corbett wrote the decision, and we published it. So the issue in this case is well, there's a couple of issues. Could the court sua sponte just basically challenge the fee? And we found that the court has an obligation to review the fees, and it came up in another context because the lawyer had I think checked a box that they weren't representing the debtor in relief from stay proceedings or something like that. And that the Eastern District judges have been keeping an eye on that and basically calling people in on OSCs and saying, hey, you have to, that's not allowed under our local rules. And at that point, the judge observed, this very high for what was really a run-of-the-mill case. And we reviewed this order for an abuse of discretion because that's what we review fee orders on. And the judge gave the lawyer so many opportunities to justify the fee. He said, hey, this looks high. And he said, no, special services and it's standard. And, he had many opportunities and he didn't do it. And the judge, he asked for more time to collect information to show that it was kind of routine in the area because he needed more time to do it. And the judge said, you know, you could do it just like I did, pushing a button, running the docket to see what you could find out, on your computer. And in the end, the lawyer didn't meet his burden. So I thought this was uh, n not an unusual ruling. And I think we publish it because we just want to remind the parties and the lawyers that the court has a duty to determine whether the fees are reasonable, whether or not somebody objects. And so you should be aware of that.
So do you expect me, Judge Brand, to be looking at every case that comes across my desk and drill down on what the fees are looking like?
I expect you to do what I do, Judge Collins, which is um, review the cases. And it's probably the same as what happened here is that this struck the judge as unusual because it was so high. It was out of the norm, and um, and to then ask a question. But usually it's going to come up for us on a fee application. This was an unusual circumstance that was prompted by the original OSC, but um, you know,
Yeah, one thing we haven't done here is kind of do a witch hunt, which is sounds like perhaps what's going on there. They collectively saw problems and they all started drilling down on all the cases being filed. That has not happened here, but maybe that's more a credit to the bar that we have here and them staying within the
mhm.
lines. Well, look,
Yeah, sorry, go ahead.
yeah, I was going to say the two worst kinds of cases are when people are fighting about fees. Well, I mean, really, that's it. Fee cases are the worst. We don't like handling them. We don't like taking money away from people. We don't like sanctioning people. But sometimes it's just unavoidable. And if there's a problem out there, we truly do have a duty to step up and do what's right, no matter how uncomfortable or unpopular it may be.
Does your local rules require the attorney to represent the debtor in like relief from stay actions or exemption objections, that sort of thing?
You have hit a major hot button here, Mr. Hayes, because
We don't, our form, you can put a list in there of all the stuff you're not going to do.
well, so you need a little background here. There was a case out of Tucson where Judge Winery saw some real problems going on with the lawyers and some financing going on with the fee. She entered a pretty hard order that Bill Rochelle just talked about in last week because Judge Winery was upheld on appeal by the district court. That whole scenario resulted in a general order from our court talking about exactly this topic, John. There was some major and I think appropriate pushback on that. And we're kind of working our way right through now how exactly that's going to work and exactly what things must happen when you touch a debtor's case. From my view, it's sort of simple, and that is it doesn't really matter what your retainer agreement says, and to some degree, it doesn't even really matter what the rules of professional responsibility say. When you file a case, you're in the case until you're out of the case. And you just better understand what it is your court is expecting you to do if you're going to touch that case and make that appearance. And if you think there's some reason that you need to get out of the case, whatever it may be, then file a motion. Don't just hang in there and then bring it to our attention and see where we go. But for me personally, look, I think the lawyer has to show with the first meeting of creditors, they have to respond to requests from the trustee for documents and turnover of money. I want to hear um, why they're not responding to a trustee's order to show cause to why the debtor ought to be sanctioned for not turning over things. Let me know that you're in the game because you're in the game until you're out. And that's a sort of a simplistic way to look at it. But look, I think one thing that everybody agrees is that if there's an adversary proceeding, a non-dischargeability, for example, that's brought by some creditor post-petition, I don't think any of us are going to hold you to that one. But most of the administrative stuff, yes, until you're out of the case or the case is closed, I personally expect you to continue to represent the debtor and demonstrate to me that you're in the game still and not just falling off the map or holding the debtor up, for example, for additional fees. Judge Brand?
I agree with you 100%. I think um, when there's an issue, it is important to be active and proactive about what you're doing, whether that is seeking to withdraw because that's what you need to do, or doing the other things that you mentioned. I think it's going to help your case a long ways on the fees. Fee disputes are really, really hard for us, as you said. Uh, we if we will do the work if necessary to review the fees when there's a challenge to them because it is our job to make the reasonableness determination, and of course it's reasonable at the time the services were rendered, not in hindsight, and that's I think where people get tripped up a lot too. Um, you have to look at it through that perspective. So I think it's important to, kind of show your work and be prepared to answer those questions if you need to.
I can understand why consumer lawyers would be sort of offended by something like this because you look at some of the fee applications in commercial cases where some of these attorneys' fees I've seen. I had somebody come in looking to be charging $2,450 an hour. I mean, holy smokes, that is not a Phoenix rate. And I'm sure the consumer lawyers feel like it's sort of nitpicky to be talking about, oh, is a fair number 4,000? Is it 7,000? Is it something different than that? Gee, I did the work and I hopefully did it well. Are you really going to punish me for being perhaps above market? But nonetheless, the bottom line is we do have a duty, and as much as we don't like it, we have to discharge that duty.
The advice from the old man in the room is from the client thinks you're their lawyer. I mean, it doesn't matter what the retainer agreement says or what that form says. I've been in court so many times where the debtor's there defending a relief from stay motion, saying, "I don't know where my lawyer is. My lawyer was. I thought they wouldn't help me. I've been calling and." The lawyer's response to that probably is, well, see on page 7 of my retainer agreement, it says I don't have to do that. Well, that's nice, but that's not, no matter what you told the client, they think you're their lawyer. We don't carve anything out, other than adversary proceedings.
So we got an interesting point by Jody Corrales in the chat box, and she says the offensive part of the general order that I've mentioned is requiring that the debtor's counsel provide a copy of the general order to the clients so that the clients know what we expect of the lawyer. And Jody, I appreciate you posting that. I know that's been part of the comments that we received from ACB a week or two ago, and that absolutely is under discussion now. So, like I say, John, it's really a work in process in Arizona about what we're going to do. This all kind of came up in the fee bifurcation issue, which has been a very controversial issue around the country, and unfortunately, we don't have any really great resolution out there from either Congress or from the Ninth Circuit. Judge Brand, have you had to deal with the fee bifurcation issue in Central District or on the BAP?
I have not dealt with it on the BAP. Uh, we've had many discussions about it here in the Central District, but we still, at this point, we allow lawyers to choose, as Jon said, what they're going to represent people on. So still, although we've had many people who want to require them to say, as part of your retainer, you're going to do, these particular tasks. We're not there.
Yeah. Well, so the comments in the chat box are continuing about this general order. When we receive comments from a number of lawyers, including the big group of ACBC, I mean, that's the motion for reconsideration we were talking about earlier. And I'm glad people are speaking up and telling us what it's really like out there. It's, been 13 years since I've been out in the practice. And while I'd like to believe I understand what's happening, we need to hear from you and we want to make this thing work. But at the same time, we have seen some abuses and we have seen some people who really aren't doing the work and they're not out of the case yet. And so this will be an ongoing problem here, or at least an ongoing discussion, I should say. All right, John.
All
Enough,
right. Well,
enough of the hot buttons, would you please?
yeah, the next one is let me. I mean, this has been a big deal in our office from a paranoia standpoint. This fee, this is another attorney's fees case in Arizona, subchapter 5, chapter 11 case. The debtor was removed from possession, and but the debtor still proposed a plan. The plan was hard fought. The trustee supported the plan. He went into court holding hands with the debtor, and the plan was confirmed. And at the end of that, the debtor's counsel, Dorsey and Whitney, filed a fee application for $1.2 million. And the opposition by the same creditor, the opposition was you were never employed by the estate. And once the debtor was out of possession, you don't represent the estate, and therefore you can't get paid. And the bankruptcy court agreed, I'm sure reluctantly, but the bankruptcy court agreed and disallowed $1.2 million in fees because the debtor's attorney was not employed. There's no court order. The debtor is authorized and employed by the estate to proceed. That's pretty shocking, huh?
Well, she's upstairs from me, so I'm not going to say anything bad about what Judge Martin did here. But that's a perfect example of how sometimes you feel like the law is going one way and the facts are going one way, and you just can't do anything except hurt who's going to get hurt here. Boy, it seems like a lot of different ways you could have skinned the cat in this one, though. As soon as the debtor in possession is no longer the debtor in possession, either counsel withdraw at that point or get some sort of comfort order from the court with notice to everybody that, hey, I'm going to continue to work and you need my debtor in possession, or you need my debtor to sign off on a plan because no other person can bring the plan. So you need me, you got to pay me, and I'm not doing anything until you pay me. That would be a totally different scenario. What might you think about that arrangement, Judge Brand, if you just remove the debtor in possession and now their lawyer says, hey, you're going to need me to stay in the game here, but you got to pay me?
I think it's really an interesting question, Judge Collins, because as John said, and you implied, this decision made me uncomfortable because the debtor's lawyer did some really good work and got the debtor, fulfilled the purpose of subchapter 5, which is to get a plan confirmed for a small business debtor. Now, it costs a lot of money to do that, just given the circumstances, but that may be a way to, an alternate way to skin this cat. Because I was thinking, how else could you accomplish this? Because I, do not disagree at all with any of the reasoning, of Judge Martin's reasoned decision. And I'm do you just chalk it up to this is one of the oddities of subchapter 5, of which there are some, because, what do you do about the situation where the debtor is the only one that can file a plan? Do you get the case removed from, sub 5 and the trustee could file a plan? Maybe that's an option depending on the circumstances. Do you do your route, which I think is a really creative solution? I wondered also, what did the plan say? About professional fees? Was there any disclosure in the plan about, these lawyers have been working really hard and they've spent a lot of money and everybody's benefiting. The creditors are benefiting by the fact that there's a plan and creditors are going to get paid. Could you have provided a vehicle for the fees through the plan? Maybe.
Great question. I don't know if that issue came up before plan confirmation.
I don't know.
If I was the objecting creditor, I would probably say, well, this plan is defective because it's proposing to pay admins to a lawyer who's not the estate's lawyer.
But if it was brought up in that context, that would have opened the discussion before the plan was confirmed, and maybe there would have been some bargaining power, and people could have maybe come to a resolution that way too. John, you said it caused concern and qualm in your office because you folks I know have a lot of subchapter 5 debtor cases.
Oh, there was hysteria. I can put it that way. I mean, I had one where I volunteered that my client was being attacked for trustworthiness, and I went to the trustee and said, "Look, why don't we turn over possession to you to help with the credibility?" And the idea that suddenly I'm out now, I can't get paid anymore. I mean, it would have never occurred to me in a million years that might come up. Well, we were talking about it with a group here, and including a retired judge who we talk with a lot here. And her idea was, file a motion to be employed by the estate, have the trustee agree, and my sense is that, I mean, I'm sure that's what we'll do going forward now. But my sense is that that's not exactly foolproof. That could be attacked based on what 327 says. But maybe Congress will. They seem to be kind of busy right now. But maybe they can fix this for us.
Yeah, this is a very, very tough outcome, but the story's not over, John, because it's now an appeal to the district court in front of Judge Brenovich, correct?
I tried to find that yesterday, and I can't on Westlaw. I wanted to look up, but yes, it's being appealed to the district court, and then on to the Ninth Circuit, I guess, and God knows what they'll do.
Yeah, Judge Brenovich, of course, just lost her husband, who's the former AG in Arizona. So I don't know how quickly this is going to get resolved. But my understanding is the appeal is still pending, and it is in front of her. But the last word's not spoken, is I guess what I'm saying.
And they didn't appeal to the BAP.
You had your chance.
We did.
All right. Well, let's move on. And the next case is another. Let me put it up here. It is another attorney's fees case that may be more useful in causing discussion than it is for what the actual ruling is. But this is a huge house. It's a house. When the case was first filed, the house is worth $100 million, supposedly, or $120 million. And the Chapter 11 goes downhill fast. By the time the case is converted, the house is supposedly worth $60-70 million, but the amount owed is $100 million. And everybody's fighting with everybody. The trustee gets into the middle of it, and the trustee makes a deal with the secured creditor. Look, why don't you let me sell the house? I can sell it free and clear of all liens, and we can get this thing over with. But if the trustee is saying, if I'm going to do this, you got to leave something on the table. And that's where my whining starts. And I'm going to leave that to maybe come back to in a minute. But they agreed to a carve out of $3.75 million. And after that, the court approved that. And then after that, the trustee files a fee application for $3.2 million. And the creditor's screaming, and the creditor's argument didn't seem to me to be very good. And the creditor's argument, from my view, basically was it's too much. It's unfair. Look, you're getting more than the creditors. This is an outrage, So the reason I included it in here is, one, so I can complain about the carve out. But two, the BAP didn't. This was Ferris, Spraker, and Gann, the BAP wasn't too bothered about anything. What do you think?
Well, tell us, first of all, I don't really understand what bothers you about a carve out in a general sense.
Well, quickly, I don't think that the trustee should be the secured creditor's agent. But it's really I've never been actually involved in one of these conversations between the trustee and the creditor. But the way the conversation goes, I'm sure, is the trustee calls, hey, why don't I can solve your problems. I'll sell the house for you. You got to leave some on the table. And the creditor, what do you think the creditor says? Okay, well, how much? The trustee says, well, let's see, how much are my fees going to be? Uh, this amount plus 50,000 for the creditors. I'm positive that's how the conversation goes. Pay me and leave a little bit for the creditors, and I'll be your agent. I'll sell the property. I'll solve all the problems you have right now with this crazy debtor. And the rule seems to be, you can't do that unless there's extraordinary circumstances. And the extraordinary circumstances are always, well, we're giving a little bit of money to the creditors. That's enough. And I'm amazed at how casual the courts are at doing that, So
Well,
that's
I look at it entirely differently because, first of all, the trustee is not anybody's agent except all the creditors, and that means secured creditors as well, and to a lesser degree, maybe even an agent if you want to use those words for the debtor. They're looking out for everybody's interests. They're trying to bring money into the estate. So, um, and I literally had something on a much smaller magnitude on this line last week, but the motion to me came in saying, "Hey, there's an $80,000 carve out." And some of these liens aren't going to get paid at all because it's a short sale, but there's only one creditor that is going to have a carve out from their side. And by the way, we haven't cleared it with them yet. Well, come on, you got to get their consent first to have the carve out. Well, and we had this long discussion on the record, and I said, I have no interest in proving anything about this sale unless you're leaving money on the table here. And this is something that eventually happened in that case that they got the consent of the people they needed. They left money on the table for general unsecureds, not just for admins, but for general unsecureds. And for me, that's a total win. The lien creditor against the house didn't have to do the foreclosure and hold that property in REO department, and God knows how long it would take for them to sell it at what price. So they got a benefit. The unsecureds got some money they never would have gotten but for this carve out arrangement. The trustee himself or herself got paid. Admins got covered to some degree. But most importantly, money was left on the table for general unsecureds. So I think in that kind of case, the trustee has served everybody. Judge Brand, do you see it differently?
No, that's usually the result. That's usually where I come out, Judge Collins. I do recognize the kind of the general issue, and w when the trustee is negotiating a carve out, and you have to think about self-dealing, in that sense, by the trustee. But what you said is completely right. If it weren't for what the trustee did in selling the property, there would be no money for the unsecured creditors. And so, you know, I guess my answer is sure, I think about these things and I look at these things, but you know, in the end, the unsecured creditors are coming out ahead of where they would have come out before. The tug of war in this case is really about what constitutes extraordinary services for really kind of looking behind the statutory trustee fee. And, the BAP has a case, Salgado Nava, which predated me on the BAP. I remember talking about it at one of our Ninth Circuit bankruptcy case law reviews, before I got on the BAP. And, basically, just because there's an imbalance in the fees is not enough by itself to constitute extraordinary circumstances to look behind the statutory fee. The Eastern District of California doesn't agree with that. They've got the Scoggins approach, and they think that that is, the right way to look at it. I think, I think it's a tough question for creditors when they get in this situation. And I think they often feel outraged. I've seen it in the circumstances where I've got trustees, attorneys who've incurred a lot of fees, and that's eaten significantly into the recovery for unsecured creditors in a Chapter 7 case. But then in those cases, I've looked at what were the fees spent for, and often it's fighting with the creditor who's complaining about the fees. And so it's really there's really a tension there, but I do agree that in the end, if there's a benefit to the unsecured creditors that they wouldn't have gotten without it, you know, it's it's a good result for the unsecured creditors.
So John kind of made the assumption that the dialogue began by the trustee approaching the first lien creditor who they are asking to take a carve out. Does it offend you that a a trustee or a trustee's lawyer might be doing that? But maybe you feel better if the creditor came to the trustee saying, "Hey, lend me a hand here so I don't have to foreclose this property. Would you foreclose it? We'll give you a carve out." Does it matter who started the dialogue to you, Judge Brand?
I don't think so. And but I do think that John is right that it's going to be the trustee that's going to start the dialogue 9 times out of 10. Um, and like you said, the trustee is working for all the creditors and really working for the unsecured creditors. And if this is the way that he can get them some money, then he can get them some money.
So, John, let's let you take the last word on this one. I see in the chat there's a comment from Frankie Adamo saying, "Is this a valid slash acceptable correlation? Colon, quote, the court commented that if it were not for the trustees' efforts, unsecured creditors would have received nothing." End of quote. What's your final take on this one?
Well, I think that the creditors got what, 375,000? About 500,000, and there were $50 million, I think. But yeah, just what I would like to throw out one last thought, and that is the day one, the client calls, the potential client. Jon Hayes, I heard about you. I need to file bankruptcy. Blah, blah, blah. My wife, my aunt, blah, blah, blah. Look, do you own a house? Oh, yeah, I own a house. Well, how much equity do you have? Oh, it's underwater. You ask that first because I need to know whether I'm going to have to worry about this guy's house. This guy I don't know from Adam, am I going to have to worry about his house? He says the house is underwater. Oh, good. I don't have to worry about the house. But now because of these carve outs, I have to tell the guy, you might lose the house. It doesn't happen very often, but it's possible. What? How could that possibly be? That's underwater. And, I don't interview clients that much anymore, potential clients, but that's the worst part of the carve out is warning people who almost surely don't have to worry about it. But because it comes up rarely, but
Well, but you're assuming that the first lien is current. I'm assuming the case is the first lien is not current. There is going to be a foreclosure, and the solution is either foreclosure or the trustee sells out from under you. But one way or the other, the debtor does not stay in it.
Oh, there's a lot of truth to that. You have to tell the client you're not going to lose the house in bankruptcy, but Chapter 7 isn't going to solve your problem by any means. But at least I don't have to worry about whether it's exempt and how much it's really worth. But anyway, it doesn't come up that often. And in fairness, it just occurred to me that there aren't any trustees on this watching us now that I have to worry about, so I can be more blunt about my complaining.
I can't say the same here. I've got some trustees here.
Yeah, but let's
John, this might be a good time for me to ask you a question and Judge Brand as well, because we're kind of at halftime here. Let's delve into what you and Judge Brand have a great deal of experience in, and that is appellate work. Number one, how important is oral argument to you, Judge Brand? And number two, John, since you were the first one reading all these briefs at the first instance, how important, or better yet, what are you looking for in a brief that is really going to move you? So let's start with Judge Brandon and the oral argument.
Uh, I, I think oral argument is important. Uh, is it the most important thing? No, the brief, and we'll hear from Jon on that. The brief is the most important thing because that is where you get to make your first and best impression, and you really get to go into the details. Oral argument is 15 minutes. So you have to really look at oral argument as an opportunity to address the key issues in your case, that the things that you really want the BAP or whoever you're arguing to at the appellate level, the district court, the BAP, or the Ninth Circuit to consider. And so there's that. And then also you have to really prepare for oral argument so that you are ready to answer whatever questions the panel has for you, because you can be assured with the BAP, I speak for the BAP, that we've read everything, we've read bench memos, and we've talked about it before we get to oral argument. We know where the soft spots are in everybody's case. We know where the potential issues are, and we're going to ask you questions about that. So you can really help us make a decision by your oral argument. So I think it's really critical to prepare for oral argument and really be ready to hit the key points and then answer the questions, because I think that's really going to help. And then, yeah, and then the other thing I would say about oral argument is that it has changed my mind, and it's changed the panel's mind. We have been kind of leaning in one direction when we get on the bench, and then we hear something at oral argument that makes us think a little bit more about that issue and possibly go the other way.
All right, so Jon, you've read thousands of briefs on appeal. What really sells for you and what really doesn't?
I'll tell you this, I was really pretty shocked generally speaking, at how bad the briefs are. In general, my job was to write a bench memorandum. Judge Brand has a BAP clerk. The judges are assigned a case, and the BAP law clerk writes the first draft of the bench memorandum. And by far, 80% of the time I spent, I think, writing the bench memorandum is trying to state what happened, figuring out what the facts are, what really happened here, and I would be going back to the docket fairly quickly because, I'm on page 8 and I'm not sure what happened. It's a motion for relief, and the bank's the bag or whatever. There's argument and there's cases getting cited all over the place, but what happened? And I mean, I'm sure a lot of people have heard the statement that once you figure out what happened, figuring out what the result should be or figuring out what the legal argument is sort of flows from that, once, and I mean, we had some cases that were really large firms. Yeah, we had one case, there were it was fraudulent conveyances of tens of millions of dollars, gigantic firms on both sides. And I started reading the brief, and by page 3, I thought I was reading Einstein's equations, and there's so many letters, and PhD did the FLY. And who are all these people again, And anyway.
So the statement of the case sounds like an extremely important thing from your view, because that's one of the first things you're going to look at, right?
Oh, well, yeah, if the statement is really true, I mean, anyway, that's the, speaking English, it was halfway through the brief. I'm like, I don't know what's going on here. I better get the complaint. I better get the judge's ruling, look at the transcript, go to the docket and see if there's anything that wasn't included. And what in the world? Why did the judge grant this motion for relief? I know everybody, the appellant hates it, and he's going to lose his house, and and the judge hated him. And yeah, I mean, I want to make one sentence or two sentences about oral argument. One thing I really learned from being, the other side of the curtain was how the BAP judges instinctively understand what the standard of review is. Within a few sentences, I could explain to Judge Brandt, hey, we got this new case. Oh, yeah, what's it about? Well, see, within a few sentences, I think she would have a sense that this is a factual problem, that's clear error. Those, it's really hard for the appellant to win on those. Or this is so you didn't, the judge should have granted a continuance. Well, I mean, what am I supposed to do about that? But when the issue is, what does 362B22 mean? That's coming up. What does that code section mean? That there's instant sort of interest. Oh yeah, that's de novo. That's reviewed de novo. Oh well, why did they say it? It shouldn't. It doesn't mean what it says. There's immediate interest. So the oral argument, if your issue is legal and it's going to be reviewed de novo, oral argument is probably huge. I mean, there are probably two reasonable ways to look at that. And the judges are, well, yeah, let's hear what the parties have to say about that. I think the first brief I ever read, it started with the judge completely blew this case because the judge said I committed fraud, but I didn't.
All right. Hey, John, I'm sorry to take us down the appellate route. We mostly have just day-to-day in trial court lawyers here, and so let's move on. And we're probably going to reach an all-time low in the number of cases you're covering today. So let's keep moving here.
Yeah, so the next case, the next case is the slasher. We can just spend a couple minutes on this. I'm not sure there's all that much to say. This is a great case. If you're having problems with the state bar, and you think bankruptcy is going to help you solve those problems, this is a great case to read because it differentiates when is the state bar trying to collect the debt versus when is the state bar trying to protect the public and punish the lawyer. This case started out the lawyer owed $3,000 to a creditor. This isn't a problem with the client. The lawyer owed $3,000. 20 years later, it's still going on, and the amount's $250,000. And the state bar gets involved and says, you're going to be disbarred for your conduct in this litigation. And the lawyer filed bankruptcy and said, well, the debt's discharged. I don't owe that creditor. And the bar said, well, that's not our problem. We're still disbarred. And the debtor said, well, you're violating the automatic stay by proceeding against me because the debt's discharged. I don't know if that's worth any discussion.
Luckily, that kind of stuff doesn't happen here. That's strictly a California problem, John. Judge Brand, any comment? I got no comment in this case, Judge Brand.
Yeah, I don't either. I think you're exactly right, John. It is a good explication of, when the discharge injunction is going to help you and when it isn't. With respect to the state bar, I think it was also very good. They published it because they just wanted to make sure that sovereign immunity was not an issue. Make clear sovereign immunity is not an issue, and younger abstention doesn't apply, and that the bankruptcy court could reach this issue. But the analysis that they did, I thought Judge Ferris did a really great job on just kind of laying everything out and really explaining how and when you're going to be successful against the state bar in a bankruptcy case with your discharge.
Okay, good. So let's move on to another automatic stay case. This is a landlord-tenant case. This is actually my case. I'm representing this debtor pro bono. Now the landlord, my client was the tenant. Uh, she filed Chapter 13, and the landlord evicted her anyway. The landlord got a judgment pre-petition. I'm going to leave out a couple facts and come back to them, but the landlord got a judgment pre-petition for possession. The landlord got a writ of possession. The landlord gave it to the sheriff, and this lady filed Chapter 13, sort of right in the middle of that. And 3 weeks later, the landlord evicted her. The sheriff came out and threw them all out of the house. And Judge Clarkson ruled that the landlord violated the automatic stay. And the landlord's response was, well, 362B22 says that if I'm the landlord, this is their home, I have a judgment for possession, the automatic stay doesn't apply. And Judge Clarkson said, well, that's what you think it says. That is what it says, but what does it mean? Plain language, that sort of thing, And the oral argument on this is going to be March 19th at the BAP. Judge Clarkson said the landlord violated the stay and awarded $31,000 in actual damages. The debtor got that by herself. She contacted me after the landlord appealed, but any thoughts on this?
I'm not going to comment because it's before the BAP, even though it's not before me.
Okay, I'm good too. Judge Clarkson's a friend of mine.
Well, the part I left out was the debtor said she never got the judgment. She never got served. She didn't know there was an unlawful detainer. She went in to vacate the judgment, and the state court said, we'll have a hearing on that in a couple weeks. And in the meantime, we're going to stay the writ of possession. So they had the hearing a couple weeks later, and the judge said, I think made it clear that the judge wasn't buying the argument that the judgment should be vacated. But the judge said, I'll rule tomorrow. So the debtor filed right after the hearing, even though there wasn't a ruling yet. So the stay was still in effect when the bankruptcy was filed, right? But Judge Clarkson's argument was, well, when it says judgment, that the judgment has to be a final judgment, and therefore it's not final under California law. It's not final until the appeal period runs, or the appeal if there is an appeal, and therefore this wasn't final. Therefore, there's no stay. All right, let's move on. Oh, the next one is this more attorney's fees. Lawyers love to hear about attorney's fees. So this is this sort of age-old question. That's the creditor is complaining about fraud. The creditor files a complaint to have the debt declared non-dischargeable. There's a trial, one side wins. Does the winning side get attorney's fees? And there's actually a couple of these cases. And for myself, I've heard this explained 10 times, and each time I think, oh yeah, I get it now. Now I understand. And then the new issue, the new facts come up, and I think, oh man, yeah, how does that work? But anyway, in Hodge, this is a lawyer who this is a litigation funding loan, He didn't disclose stuff. The lender says, well, he didn't disclose stuff. The creditor won, and the creditor asked for attorney's fees, and the court denied the attorney's fees. Any thoughts on that?
Go ahead, Judge Brand.
Well, this is a Ninth Circuit opinion, right?
Right.
And it's one of their unpublished dispos, so it's 3 pages. It's real short, so it's hard for me to really opine on this one because other than just taking it for what it says, because these unpublished dispositions from the Ninth Circuit really are kind of very short on the factual basis and even often short on the law. So it's hard for me to talk about this. They said they had to interpret the contract, so in order to determine whether there was fraud, so attorney's fees.
Any thoughts, Judge Collins?
Well, I mean, that often is the issue at the end of a fraud trial. And, in Arizona, they'll say, well, this all arose out of contract. And look at Arizona statute 12-34.01. But the problem in these cases, of course, is it's a fraud case. It's not really a contract case. They have, in state court, they would have pled a breach of contract and this and that, and then also, fraud and the inducement. And but fraud is fraud, not a contract matter. But look, I've been persuaded before that it really is a contractual related deal, and that it is perhaps fraud in the inducement of that contract, or some other kind of fraud that is really very closely pinned to the contract itself. So that's a tough call. I'm not very helpful here for you.
Yeah, I mean, I guess I would add is that these cases are really hard to make the call on in this case because it really, there's often good arguments on both sides.
It's not a clean cut between contract and tort. It is, yes, the 523 actions are usually tort related, but they are often embedded in a real contractual relationship. John?
In this case, it was a failure to disclose. Where does it say I have to disclose something? The argument, according to the Ninth Circuit, was that the duty to disclose came from the contract, and it required, therefore, that the contract be interpreted in order to figure out whether there was a duty to disclose, which led to the fraud charge. And the debtor, who's an attorney, was arguing that the creditor had no standing, that the contract wasn't even enforceable among the debtor. It was sort of irrelevant, according to the debtor. And the bankruptcy court ruled, no, I have to look at the guts of what I was ruling was based on the contract. So even though my ruling was fraud, the fraud came from the contract. And of course, the bankruptcy court then said, no, this is just fraud. I can't award fees. And the Ninth Circuit reversed. All right, so we actually.
So the next case is really the corollary to that, but in this one, the defendant won, and their judge client did give attorney's fees. And so I think it's kind of the same issue. And if you don't mind, John, let's blow by the Guzman case and go to the one after
that. Yes, let me roll by. Yeah, that was pretty much the same thing. So Mannion. Yep. Let me share the Mannion case. This is Judge Spraker.
Judge Spraker at the bankruptcy court.
Right.
Yep. And it's Lafferty Brand Ferris at the BAP.
Yeah. So this is one of these merchant MCAs, these merchant credit cash accounts. The creditor bought $472,000 of accounts receivable, supposedly for $350,000. The debtor filed bankruptcy. the creditor came in and said, well, you failed to disclose that you lost a major account. And the debtor won. Uh, so what do you think about this? Let me stop talking so much.
The debtor didn't win. The um, uh, the lender won because I think Judge Spraker wrote a really long opinion, as he is wont to do, even when he's not on the BAP. He writes great decisions, which I am grateful for, um, because he found and we affirmed that the debt was not dischargeable as fraud. And to me, uh, if this case and the cases that follow it in your outline really present issues regarding what is fraud, and is it a fraudulent financial statement? Isn't it? And this goes back to your prior case. Here was an omission, and does that constitute fraud? And that was really the meat of the issue here was the debtor had an obligation under the loan agreement to disclose any material changes to their financial condition, at the time of signing it. And they didn't disclose that they lost their biggest account right beforehand. And, of course, because they lost that account, they couldn't, they received the money and couldn't pay it back. And a few months later, there was defaults and bankruptcy ensued. And so the question was, what's the import of that for non-dischargeability? Is it a 523A2A issue, for an omission, because an omission can be fraud? Or is that a fraudulent statement regarding financial condition, which has to be in writing, and then it's only a 523A2B issue? All of these things were in play, and I think Judge Lafferty wrote a really thorough analysis of these types of issues, and I think uh, for the bar, it's a really good case to read because it kind of tells you that you have to look at the conduct that's at issue from more than one perspective, either as a plaintiff or a defendant in these non-dischargeability cases, because it's going to tell you kind of what kind of claims you could possibly make, but also what kind of defenses you might have. Like, this isn't a 523A2A because it wasn't a fraudulent omission, and Judge Lafferty recognizes that there's overlap in the types of different non-dischargeability actions certain acts can be, and so and how do you deal with that? And so that's what I think is really interesting about the case. And Judge Collins.
Well, when you talk about overlap, I mean, literally, it was a breach of contract because of a provision that said you have to disclose and you didn't. But it just kind of highlights that a lot of these cases are breach of contract cases, but it's the fraud that you have to drill down if you're hoping to have it not a chargeable case. So, yep, you're right. Good opinion to read, and I recommend it to folks.
All right, well, let's move on. I don't think we could sort of do this in a couple of sentences too, I think, but these EIDL loans, they're coming up every day. Back to the clients calling, oh no, I got this gigantic loan. The reason I put this in the materials is it's not so that this lady didn't disclose litigation that she was involved in. So from that standpoint, it's sort of the same thing. But what really caught my eye is the SBA was saying that she didn't use the money the way she promised to use it in the paperwork. And the Judge Montali agreed with that, and not only said it's fraud because she didn't disclose the litigation, but there's 150% penalty So the loan was roughly $1 million, and the judgment was $2.5 million because she didn't use the money the way she promised to use it. Any thoughts on that?
Uh, n- uh, I think it is alarming that, she was liable for the penalty. I just kind of as a warning shot for the bar. To me, this is a follow-on to the Manning case because he found liability under that she was liable under both A2A, 523A2A and B. So she, made false financial statements in writing. The whole loan application, he said, was the writing. And, but also, she omitted information that she should have disclosed.
I've got nothing to add to that one.
All right, let's move on some more. So the next one is Warfield versus Nance, the Arizona case. Oh, shoot. Sorry, let me put it back up. This is again, the lawyer, I hope the lawyer isn't on watching this, but this guy filed Chapter 7 in Arizona. He had just moved here.
Mhm.
I don't know what just moved here in the last 2 years anyway. Had moved from Washington, the state of Washington, so he claimed the state of Washington exemptions. The trustee objected and said, "You don't get the Washington objections." Rather than respond to the objection, he amended and said, "All right, well, I'll take the Arizona exemptions." So the trustee objected again and said, "Well, you don't get Arizona exemptions either." And the debtor didn't respond to that. So the court sustained the trustee's objection. The debtor amended again and said, "Well, then I'll take the federal exemptions, 522D." And the trustee said, "Well, it's too late. This is preclusion. You already amended the exemption that was sustained. You can't amend them after that." And the bankruptcy court said, "No, no, no, that isn't how it works." The district court reversed. The district court in Arizona reversed.
Well, the bankruptcy court said a little bit more than that too, right? And that's partially what offended the trustee because the bankruptcy court had said, well, I mean, what about a wild card? And kind of put that on the table when the litigants themselves didn't. What do you think about that piece of it, John?
Oh, I was happy to see the judge being pragmatic about it. But yeah, they had this RV, and the debtor didn't claim the RV exempt at all. And at the hearing, on the judge said, "Well, but it's clearly exempt. You clearly can use the wild card to exempt the RV." So he ruled for the debtor on whether the RV was exempt, even though the debtor hadn't claimed it exempt.
I got to tell you, that's a hard one from a judge's perspective because on the one hand, you may know what the law is, and it doesn't seem like it's coming your way. You might know how the facts fit to this case and what the real solution is here. And yet we have an adversarial system, and to what degree should we just sit and watch it happen, even if it turns out to be a result that they didn't think of? Judge Brand, that's a tough call, isn't it?
Yes, it is. Yes, it is. And, we face that issue frequently. Um, and so, I think we have to just deal with it on a case by case basis, how much you uh, can suggest things, or in this instance, just actually, find that the wild card exemption applies. Often we are pragmatic and try to get to the right result to save people money.
I know in this case, the district court came out with a ruling reversing Judge Gann, and Judge Gann was sort of hot about that one. But in a sense, Judge Lanza at the district court said essentially, enough's enough. How many times are you going to give them a shot at the apple here? This is the third bite, and that's one too many. The Court of Appeals didn't see it that way. And what did they say, Judge Brand?
Well, I thought the Court of Appeals decision was really interesting because what I saw was pragmatism in there, which we often don't see at the Court of Appeals. That went through the whole analysis regarding this whether or not there was issue preclusion, and clearly it's a final judgment. These rulings overruling exemptions are final judgments. And then did a very, very thorough analysis of whether issue or claim preclusion applied. And basically, because the debtor could only elect one exemption scheme at a time, you can't do it in the alternative. The forms don't let you do that. The circuit said that it's that it's not the same transaction, so it's not the same. Issue preclusion or claim preclusion does not apply. And they invoked 105. Well, for purposes of the wild card, they invoked Section 105. They said the governing federal scheme is interwoven, that it was a technical error, and and so they found both that there's no issue preclusion, they could claim the federal exemption, and it was okay what the bankruptcy judge did by proactively saying that they also could exercise the wild card exemption, even though they hadn't asked for it.
Yep, there you have it, John.
All right. Let's move on. What happened here? Yeah, maybe we don't need to say too much about this, but this is sort of a follow-up to Bartenwerfer. The debtor's child injured somebody at school, and under state law, the parents are liable for the child's tort, and the debtors filed the child's parent, the child and the parents that was injured sued the parents of the child that did it, and the parents then filed bankruptcy. The creditors, the injured child's parents filed a non-dischargeability action and said it's willful and malicious injury. And look at Bartenwerfer. There's vicarious liability. The debtors are liable, even though they're the ones they conceded that they did not do anything willful and malicious. Their child did, but this was Spraker, Gann, and Lafferty. What do you think about that? I mean, I have another thought, but let me hold off.
It's different than Bartenwerfer, of course, because there it was an agency relationship, and your agent did the bad thing, and it goes to you. That's kind of the same thing that happens if you're a general partner with somebody. If your general partner does something bad and you didn't, their acts are your acts. This is a different twist on that. And Judge Brand, why do you think it came out differently than Bartenwerfer?
I think there's a very nice analysis of the Bartenwerfer in this decision, and it came out differently because the statute is different. Under 523A6, it plainly says that the willful and malicious injury has to be by the debtor. Bartenwerfer talked about 523A2, the fraud non-dischargeability provision, which does not require that the fraud be actually committed by the debtor. So it's founded on that, and it's also bounded on the agency partnership law. Bartenwerfer is, and this is just a different situation, and you basically can't extrapolate Bartenwerfer into 523A6, where that statute specifically requires that the injury be caused by the debtor.
Anything else on that?
Not for me.
Nope.
Uh, that's actually the part Judge Brand just said the part that I was going to add at the end. So let's, the next case, I don't think I think we can sort of skip, but the only reason I included it, this is a student loan. It's Judge Chris Klein. It's really fun to read, if you need, especially if you want to read some long words. But Judge Klein really goes off on or sort of a debtor's attorneys. These student loans aren't impossible to win. Look at it carefully and uh, uh, bring these things more often because they're more winnable than people think. Any thoughts
Mhm.
on that or anything to add?
Uh, all I'd say is it's a good read. And if you're going to be filing a non-dischargeability or filing an action to have a student loan debt discharged, this is a good place to start because it lets you know what all the rules are and how, and kind of gives you a framework for approaching it.
So, Judge Brand, you and I took the bench about the same time. Early in my time, I had a fair number of cases brought to me and were tried on these educational loan non-dischargeability actions. But that's been a long time. My experience these days is while there's still quite a number of these cases filed, the DOJ lawyer usually seems to work it out and these cases go away. What's your experience?
Same experience here in my court, and I think generally in the Central District, they are very actively working each of these cases to see if they can be resolved under the current program.
Yep. So, John, this next one is porch, right? And
That's you.
that's my case. So let me just take this. Let me take this one from the top
Sure.
because my hat's off to Cody Jess and Crystal Ahart in this case because they brought all kinds of kitchen sink issues to me and a lot of them are really interesting. But the essence of it was this. There was a pre-petition default judgment obtained by the creditor. That judgment lien was recorded before the bankruptcy. Debtor files bankruptcy, and then not long after that, uh, well, at some point along the way, Arizona changes the homestead exemption from 250 to 400. And then during the bankruptcy, the creditor brings a non-dischargeability action. So Crystal files two motions, one to under 522F to get rid of the pre-bankruptcy judgment, and then the recorded post-bankruptcy non-dischargeable judgment. She wanted to get rid of that as well, and Cody wasn't so happy about that arrangement. So one of the things that comes up in that case is yet another case that I had along the way that the Ninth Circuit had, and that was called Tillman, where the court said exempt property is not property of the estate. I absolutely did not think that was right, and the dissent in that case didn't think they were right either. And yet, that's what the case law is now. And so, the view here from the creditor was, hey, when the debtor filed bankruptcy, claimed the exemption, and nobody objected, then it's no longer property of the estate. And so, why are we talking about a 522F motion? It's the debtor's property. It's not the estate's property anymore. Bankruptcy court, you don't have jurisdiction over this one. And there are cases out there that essentially say 522F motions are a personal right of the debtor. Whether it's property of the estate or not isn't really the test. And so I said, well, look, I think I do have jurisdiction here on this one. Um, then then there was a move by the debtor's lawyer saying, oh, well, no, I'm sorry. Then there was one more thing. Now that there is a 522F motion to remove that pre-petition judgment and the post-petition judgment, the creditor says, well, look, I am not barred from objecting to the exemption here because now that you have brought the 522F motion, I get a new shot. I get a second chance and a second bite at the apple to object to your exemption. And to my amazement, there is a BAP case called Morgan that says that. Sorry, Judge Brandon, I know you're on the BAP, but I wonder about that one. But look, I've said for a long time, I follow the BAP unless there's something clearly in the district court that tells me to do otherwise. So I felt like I really needed to give the creditor a second bite at the apple. They ended up losing that bite, but and they also ended up having both their liens removed because the real principal issue that I thought was going on in this case is even after the bankruptcy is filed and a non-dischargeable judgment is obtained and a judgment is recorded, can the debtor use 522F to remove that post-petition judgment lien against the homestead? And there are cases that say you can, and that's exactly what I said here. Judge Brand, it didn't get appealed, thankfully, but tell me why I was wrong.
No, we'll probably say thankfully that it didn't get appealed too. I think this is a really interesting case, and really interesting issues. And these actually are the types of things I'd like to see at the BAP because we don't get to see them that much in our home court. And and they're the type of issues that are great to dig into. Um, I can't tell you that you were wrong, Judge Collins. Um,
That's only because I followed your friend Elaine Hammond up in San Jose.
yeah.
Because she pretty much had the very same issue on the 522F, not a chargeable judgment post-petition. So,
Yeah, very interesting issue.
so John, maybe you should tell
Us-
me why I'm wrong.
oh, I'm 100% for this one. You can tell the debtor blood in that runs through my body, and I think it's 100% right. I was a little disappointed it wasn't appealed, so we could get, a court of appeals to affirm it.
I got to say this for the benefit of the bar here, and this is why I really take my hat off to Crystal. Um, she probably didn't get paid in full or much of anything here, and she was fighting battle after battle, and she just stuck with it, and she did what really a good lawyer does, which is just fight the fight and then see what the court does. And it turns out in this case she won. It's not always going to be the case, but she didn't just fold like some people might have in this case. So I like that.
Great. All right. Well, let's maybe we're coming up around 15 minutes. If one of you have a case that you really particularly want to get to, let me know.
I do. And Judge Brand, we talked a little bit about this in our prep session, and it's a recent decision from the Ninth Circuit, but the opinion was written by a district court judge in Tucson. And I'll call it Orantes because the actual name I can't pronounce. It's something like Ogalanapur or something like that. But this case was interesting, I thought, because it rang the daily double. It had the Barton Doctrine and it had the Rooker-Feldman Doctrine. And why don't you just tell everybody or remind everybody what the Barton Doctrine says?
The Barton Doctrine requires um, a party to obtain permission from the bankruptcy court to proceed with state court litigation against a professional of the estate, the trustee, debtor's counsel, related to um, uh, their activities as in the bankruptcy case.
Yep, that's exactly it. And now there's lots of variations on that, and there's some limitations have been set forth in the last few years. But then let's turn to Rooker-Feldman. Essentially, what does the Rooker-Feldman doctrine tell us?
Well, that we have to recognize and acknowledge state court decisions. We can't. The bankruptcy court, put simply, is not a place to go to appeal a decision you didn't like that you got in the state court.
Yep, I think you're right, exactly on both of those. But it's a rare case that has both those issues come up in.
Yes, it is.
Now,
Yeah.
the facts of this case are seriously convoluted, and I don't think it's even important to talk about them. Bottom line is, they come back to the bankruptcy court after having filed the litigation against the estate lawyer in state court, and they came back to the bankruptcy court and said, "Hey, could you just bless what we had already commenced?" And the question was, do you have to get that blessing before the litigation started? Because there may have been a statute of limitations issue in this case, and they couldn't refile it if it got dismissed then. And I think the one clear decision from this is that uh, the best policy is as soon as you have a claim against an estate professional, go get the relief from the bankruptcy court on the Barton Doctrine. But what the Court of Appeals said is the bankruptcy court's duty is to say, yes, I'll give you leave under the Barton Doctrine, or no, I won't, but nothing more. And part of the reason this case went off the rails is because the bankruptcy judge said, a little bit more than yes, you can go forward. It's here's how you should go forward, and had a lot more table talk than the Court of Appeals thought was necessary. So at least on the Barton Doctrine, it's a gating issue by the bankruptcy court, and it's either up or down, end of story. That was kind of my takeaway as a bankruptcy judge. When I've got a Barton Doctrine, it's either aye or nay, nothing else. What do you take away on the Barton Doctrine, Judge?
I agree with you. Um, it gives a clarity, I guess, on what our role is and what we should do, to the extent we didn't have it before. As a bank, sometimes I don't agree with what the courts do, but on the other hand, sometimes it's like just to have a line, a rule. You have to follow this rule, and so this gives us the rule. What did you think, Judge Collins, about the Rooker-Feldman issue?
Well, so essentially, they bought off on the dissent that Judge Gann had at the BAP level,
Hmm.
and essentially what he said is, look, if there is a Barton issue, then the bankruptcy court really just says aye or nay, and you can't possibly get a Rooker-Feldman violation because you haven't done anything to overrule or question what happened in the state court. And that too is a pretty good bright line, gating issue. And I think it's right. What do you think?
I'm still digesting it, really. Um,
It's clean and it's
it
straightforward.
right, it's clean and it's straightforward, so we kind of have to we just have to go with it. Um, yeah.
Plus, Judge Gant's a good guy, so he got a W on that one, even
He
if
did. He
even
did.
if his case got appealed, and then he got the W. So,
The problem with the case was that I was working for Judge Lafferty when this case came along, and the problem is that Judge Kaufman's actual order said the debtor may proceed in this case uh, uh, outside of the bankruptcy court. And the case had been dismissed at that point, the state court case.
Hmm.
So the actual words that the judge used sounded like it was correcting what the state court of appeals had ruled, and what the state court of appeals had told the lower court judge, the trial judge, to do. It sounded like Judge Kaufman's order was, look, state court, I've decided this matter can go forward. That's what it sounded like it said. And that's where Rooker-Feldman came in. If the order would have just said, Barton, you got my blessing. Barton, that to the extent you need my permission to proceed, you got it. I don't think there would have been any issue, but
yeah, I'm sure she kind of regrets adding a few other words to it, but it seemed like her
Yeah.
intent was leave me alone, go on your Barton
Right.
path.
yeah. The do you have another case in mind? We
I
we
Well,
should do
go ahead,
this.
Judge Brand.
Go ahead.
I had raised one case, the Mission Hen LLC
Right.
versus Lee case. Um, I thought that was a great case when it was at the BAP. I think we talked about it, John, when it was a BAP case in one of these panel sessions in the past. And I was happy to see it was affirmed by the Ninth Circuit because it settled some Chapter 13 um, issues, which I think is useful to the bar and to me, both. I liked, it had a decision regarding eligibility, the SCOVUS, and kind of a flexible approach to eligibility. They basically agreed with the analysis of the BAP. And I have to say the BAP's, if anybody's interested, reading the BAP decision is good too. It was written by Judge Ferris, and it really went into great detail on the eligibility issue. In this case, there had been the debtor made an error in filling out their schedules such that they were plainly on the face of the schedules ineligible for Chapter 13 relief based on their debt. and the creditor knew about this, knew about this eligibility issue and didn't raise it for quite a long time in the case. They didn't raise it until around the time of the third amended plan, second or third amended plan. And at that point, there'd been a lot of activity in the case, including a valuation hearing, a contested valuation hearing by the court that that set the value of the property, and based on that valuation, the debtor was eligible for bankruptcy. And the BAP said, and the Ninth Circuit agreed, that said, look, it doesn't make sense to follow the Scovis rule where you look at what the schedules were at the time that they were filed. When the case has gone on, the creditor hasn't objected, and you've got better information now as a result of actions that transpired in the case. You shouldn't ignore the finding of value of the court to make a mechanical finding based on the Scovis situation. Now, they recognize this is not your normal case where this comes up, but it was I thought it was a well-reasoned decision, and it gives bankruptcy courts and lawyers something to think about in terms of the eligibility issue. And I also thought that the issue regarding the modifying the lien of the undersecured creditor on the home in Chapter 13 plan when the plan comes due during the plan period. I thought both the Ninth Circuit and the BAP dealt with that issue very well.
How can I do better than that? I agree with Judge Brand.
I think in the Central District, this idea of modifying a loan on your home, the courts it had become fairly casual that you can modify the loan if the loan comes due by the end of the plan term. So if the loan was due before the case was filed or came due during the plan term, it can be modified. And I was really happy to see this, that the BAP affirmed that and said that's right. I also thought that I like the language about feasibility, that it doesn't have to be ironclad. The parents are saying, look, we'll take care of the payments. And Judge Houle agreed that they didn't have to sign their life away in blood, that they would absolutely make them no matter what. Their promise was enough. So if you have a feasibility issue, this is a good case to read.
Yep.
So, John, you're not going to, well, actually, you might be stunned to hear which case I'm going to call out. And it's the very last one from our friend Judge Trust in the Eastern District of New York. He's just about to retire next month. But the facts seem like they're totally one-off, but they're really not. And this happened in Arizona as well. And this is why I want to talk about it. In this case, Mader, a debtor filed a Chapter 7 petition. There was an abuse claim that the debtor had, but was long since barred by the statute of limitations. The debtor did not list it in the schedules, didn't list in the statements. The trustee heard nothing about it. Case gets closed. Years later, New York, like Arizona and like California, and I think like a lot of other states, revived the statute of limitations on basically sexual abuse cases on minors. And so now they've got another 3-year shot under a statute of limitations that is a brand new statute. And there, the debtor, long after the bankruptcy, files the claim, and the trustee comes in and learns about this action and says, "Hey, that's mine." And there, Judge Trust said, "No, if the date of the petition, the claim value was 0 because they were barred by the statute of limitations, and that's a big loss for the creditors and for the trustee." In Arizona, it comes up through the state courts, and there was a reported Arizona Court of Appeals case with a dissent. But in the majority, they said in that very same situation, the claim was not property of the estate, and the Chapter 7 trustee therefore had no jurisdiction over the claim. When I read that, I thought, no, that's wrong. And the dissent says, no, that's wrong. It is property of the estate. And so the interesting footnote to that one is somehow it gets to the Arizona Supreme Court and they vacate the Court of Appeals judgment, but they don't do anything themselves. My sense is perhaps this case just got settled. So we don't know really what happens in this kind of case. There is no officially reported decision in Arizona, but maybe Judge Brand, something has happened in California or elsewhere, because it's kind of an interesting scenario.
I do think it's an interesting scenario. I have not seen this come up here. John, have you seen it come up at all here?
Not recently. We've had these where I think the Dalton Shield case, where all of a sudden there's money and people, women that didn't even know they had an issue, are suddenly have the right to money, and the trustees were going back to see whether there had been a prior bankruptcy filing, and we were struggling with, and usually we made a deal fairly easily. But we were struggling with how, I mean, if the issue was there on the petition date, there's a right to payment, there's a claim. There's an asset called a right to be reimbursed.
It's one thing to say, I didn't know I had a claim, and I discovered later I had a claim, but these two cases that I'm talking about, those claims were barred by the statute of
Right.
limitations. And to me, that's just a defense. You can always bring that claim. You're just going to lose if somebody gets wise to what the defense is. So I didn't see it as not property at all. And so I just thought the Arizona majority opinion Court of Appeals was, according to bankruptcy statutes, wrong. So
I
anyway.
thought that the Judge Trust had a really elegant, nuanced analysis of that issue, which made a lot of sense to me.
Yep, I agree.
I wasn't too sure about the fact that he said, well, there was a claim, and by the way, it was decades old.
Yes.
No, but there was a claim, but it was valued at zero, and the debtor could have claimed it exempt, and therefore it's not property of the estate. That's like having worthless stock or something that becomes that grows in value for some reason.
So John, one thing I do know about this crowd here is nobody wants to go into overtime, and we're right at our 2-hour mark. And so I really appreciate people hanging in there, at least on their dark screen, and hopefully they've enjoyed the discussion, and really appreciate you, John, for coming to Arizona to lead the charge. And of course, Judge Brand, unbelievably busy and yet took the time to do this. So very much from the Arizona bar perspective, thank you for doing this today.
I'm happy to do it. Thanks for inviting me.
And I really, it's really quite an honor to be able to be involved in this, to listen myself to the different analysis. I don't know if Diane's going to come on and say
Yes.
bye to everybody.
Yes, Diane is going to come on. Now, I made an informed decision based upon my own brain, and I gave you all 2 hours of ethics credit. Now, it's up to you whether you want to claim that or not, but I honestly don't see why this doesn't qualify for ethics credit. So the certificate that I just posted, and I will post it again, has 2 hours of ethics in the cert. Okay, and so this has been fabulous, guys. Thank you very, very much. I know 2 hours is a long, long program. And I appreciate the depth and the materials. John, thank you very much for preparing all those. That was fabulous. Any questions? Whoops, my beeper's reminding me to turn off the recording. Well, I'm not going to do that until I know we're done.
Well, if we're going to go into overtime, it's going to be somebody on the screen, and it's not one of the presenters that's going to bring you into overtime. So,
well, shall we do that? Shall we ask the group if anyone has questions, or do you not want to open that floodgate?
I'm here. Let's go.
Okay.
Let's hear what they say.
You heard the boss. Anybody have questions? Just go ahead and you should be able to turn both your speaker and your video on yourself.
You.
Okay.
All right.
Nobody's awake anymore. That's the real problem of a 2-hour presentation.
Yeah, I hear you.
Yeah, I enjoyed it.
Thank you very much.
All right. Well, we'll call it
Thanks.
quits. And you all, thank you very, very much. Judge Collins, Judge Brand, and Jon, thank you. This has really been on your shoulders, so I appreciate it completely. And really, from a practitioner standpoint, this is more valuable to me than any type of program, because you get to hear the judges from where they're coming from, and their questions in their own brain about, no, I don't know, how does that work, etc. So we get to see behind the curtain just a little bit. Thank you very much for sharing with us.
Plus, they got a chance to diss us in the general order chat box.
Right, yes. You'll notice I kept my mouth shut. Yes.
I know it's controversial. I know it's an important issue. It's not over yet.
No, it's not. And but it has the history behind it with poor Winry and poor you with your mass production case that you had, what, 15 years ago now or whatever it was. Lord Almighty.
Yeah.
Anyway, I'll shut up about that. Okay, turning the recording off now, unless you all have something really important to say. All right, everybody go away, go have lunch.